Good afternoon, friends. I extend a very warm and hearty welcome to all the participants to this and the learned speaker to the 85th webinar on discussion and deliberation on the recommendation made by the Company Law Committee. This is being organized by corporate professional as a part of his knowledge sharing, which we are doing since last 85 weeks. In line with the government's objective of promoting ease of doing business to law-abiding corporates and also to address emerging issues having impact on the working of corporate in the country. The Ministry of Corporate Affairs have constituted a Company Law Committee, CLC, for examining and making recommendation on various provisions and issues pertaining to implementation of Companies Act 2013 and LLP Act 2008. CLC has submitted its report on 21st March, recommending several changes, which include realignment of financial year, issuance of fractional share, the SAR and SRU on ESOP, raising capital in distressed company on discount, self-declaration instead of affidavits, holding general meeting through use of technology, maintaining a statutory register through electronic platform, some IEPF related changes, strengthening NFRA and audit framework, then revision of provision of disqualification and vacation of directors, reviewing provision on merger and amalgamation of small companies, easing the restoration of stock of companies, recognition of SPAC, facilitating e-adjournment and e-adjudication, and new concept of producer LLP. The committee has also recommended several drafting and clarificatory changes. The objective of the webinar is to discuss and deliberate the recommendation of CLC and their impact and preparedness for them. Preparedness means that suppose this is coming tomorrow, so what are the structural changes you have to do in your planning? The corporate world should be ready. The suggestion coming out in the webinar will be compiled and forwarded to the NCA for its consideration. We have bifurcated and recommendation in some major heads like this. And accordingly, we have allocated topics to all the speakers. Ease of doing business, investor education protection fund, auditors, corporate governance, technology and IT, capital market related changes, merger and amalgamation, trust and cooperative society and Nidhi, and limited liability partnership, and drafting and clarificatory changes. So entire issues which government, the committee has recommended, we have divided into these headings. And we will discuss these headings with the help of galaxy of experts, those who are here, who will analyze the various recommendations contained in CLC report, and they will give us what will be the impact. And if something is coming and in that there is a confusion is there, so we can preempt to government that these are the confusion. If you are making law, if you are recommending and accepting, please follow this part. So we are doing proactive approach, following this and then identifying the issues and then doing this. For this, we have the expert in this area, Amit Gupta. He is PCS insolvency professional. Mr. Ankit Singhi, who is head of corporate affairs and compliance corporate professional. Mr. GP Madan, founder Madan Law Office and chairman NCLT, IBC committee of PSD. Then we have Mr. Manoj Kumar, partner M&A and transaction advisory. Then we have Mohini Bhashne. She is partner head and ESOP and insider law of corporate profession. KS Ravichandran, managing partner KSR, will join shortly. And then we have a new face today, Mr. Gaurav Pingle. So all other speakers you are aware. So without devoting any further time, I'll just tell you that Mr. Gaurav Pingle is associate member of ICSI and commerce graduate with 11 years of experience and industry expert advising on business setup in India, core company law matter from day-to-day compliance to advisory, FEMA law, SEBI listing regulations, security law for domestic multinational and listed company. He is a researcher and a popular teacher of corporate law, and he has written various books, and I admire Gaurav in this young age. He has done so many good things. Welcome, Gaurav, for this program. So friends, let now start the discussion on recommendation made by CLC report. Ankit will make a presentation on the recommendation of expert, will analyze the same one by one and also give their suggestion and comments on the recommendation. I request to participant also to send their suggestion and comments on the respective CLC recommendation so we can take. I'll just again explaining you the point which will come on the screen. I will ask expert that what will be the impact of this change, number one. Number two, what will be the changes government should plan in such a manner that in place of giving a new law, it should not create a confusion. So the floor is open. Anybody can ask any question, write it here, and accordingly, I will ask questions. We have allocated topics to all the experts, so they can give reply. But in case any other experts wants to add some additional value added point, they can raise their hand and I will ask. So over to you, Ankit. Please give your presentation one by one, and I will start with this. Yeah, screen is visible, Ankit. Carry on.
Thank you, sir. Good evening, everyone. We are here today to discuss on the recommendations of the company's law committee. So just to take you to a brief background as to from where how this committee came into force. Just a second. Okay, so the first committee was formed in year 2016, and which gave its recommendation in form of Companies Law Committee report, which took the shape of Companies Amendment Act 2017. Thereafter, in 2018, there was a committee which was formed to review the various offences under the Companies Act to decriminalize. Basis this committee's report, the Companies Amendment Act 2019 was introduced, which decriminalized a lot of provisions which respect of penal provisions, criminal provisions to under the Companies Act. Thereafter, in 2019, the mandate was again given to the Company Law Committee to look into other factors with respect to ease of doing business and other related areas. And after a period of Sir, my slide is changing or not?
No, slide is not changing. Your voice is also. So just change the slide.
So I am already on my second slide. Is that slide visible?
Just
let me reshare. Let me reshare. Is it visible now?
Just try to shift second slide. No, it is not coming. Okay.
Make it full screen first, then try.
No, I am changing all my slides. I don't know why it's not working at your end. Just a second. Is it visible now?
Now it is visible. Yes.
Let me try to use this only. Okay, so I was on to the history of Companies Law Committee. That the first committee was there in 2016, and it's thereafter there was another committee to review the offences, and now this Company Law Committee report, which is there currently, the committee was again given mandate in 2019 to look into various issues related to Companies Act, and some of the issues are with respect to the introduction of novel concepts under the Act, improving existing procedures to reduce burden, changes in the LLP Act, introducing clarificatory changes under the Companies Act, and changes related to ease of doing business, information technology. And considering the entire mandate, the CLC committee has given its detailed report in which it has made around 28 recommendations with respect to changes under the proposed law. And keeping in view the history, every time CLC committee has given some recommendation, most of the recommendations have formed part of the Act by way of the relevant amendment Act. So post receiving comments on this report, it will undergo the legislative process of converting it in form of a bill, going through the entire parliamentary process. As Sir mentioned, today we have classified the entire recommendations of the CLC committee in various heads, and I'll try to take you one by one under each head as to what kind of recommendation is there, and we can deliberate on the recommendation at that point of time. So starting with the ease of doing business, so the first recommendation, the committee felt that while there is a provision under the Companies Act which provides for a financial year ending March, and there is a proviso where a company having foreign subsidiary, foreign holding, or associate company is allowed to keep a different financial year subject to the approval of a regional director. But there is no provision to revert back to the situation in case it wants to go back to the normal financial year of April to March. And as per the committee, there is a need to realign the provisions, and necessary provisions should be introduced where a company can revert to the original period of financial year, that is from April to March, subject to approval of regional director. But that can only be as per the proposed provision is allowed when the company ceases to be any relationship with the foreign company on account of which it has earlier sought the approval of a change of financial year. And to consider this case, you have to file a reapplication to the regional director to obtain its approval for the reverting back to the financial year. While if you read the provisions of the Act, as a proviso, it only says that you have to revert, if you have to change a financial year, you have to take an approval of the RD. But there is no provision of reverting back, and I don't think there is a need of actually reverting back to, there is a provision of going to reverting back to the original, because original is already allowed under the Act that you can keep a financial year from April to March. But I have come across that applications are being filed to regional directors from existing companies who want to realign their financial year from April to March, and RDs at some jurisdictions are approving this application. While if for a clarity perspective, this brings clarity, but then it brings two negative contours to the provision. First, it requires you to again go back for an approval. Why we need to go back for an approval if I'm reverting to a position which is the law originally mandates? And secondly, it now stops companies from reverting back only in case they ceases to be subsidiary or a relationship with the foreign companies, which I don't think is the right idea or right move, because while companies of operational reasons try to move out to the financial year suiting to their international counterparts, but same operational reasons at times also force them to revert back to the financial year they follow in the law of land in India. And now only allowing those companies which have no relationship in international jurisdictions to do that would in some way limit the right of these companies to comply with what the original requirement of the law is. But as of now, this is what the provision provides, that there is, if you want to revert to the original plan of April to March, you have to take an approval of regional director, and it is only allowed in case your relationship is no more existing.
Okay, Ankit, you have right. Amit, what is your view? What Ankit has said, is there any other logic and any other problem you have faced?
So I completely agree with what Ankit has summed up with regard to this provision and the background. So as we understand, in departure to the provisions of 1956 law, where the financial year was not required to be uniform all across the different companies. Companies Act 2013 mandated a uniform financial year to also meet the requirement of income tax, because under the income tax, the previous financial year and assessment year concept is there, and that is uniform. And in any case, all the companies are required to file the income tax return. So for that purpose, this alignment was proposed. Now, while this law was enacted, the government was conscious that there may be situations due to holding subsidiary relationship, the companies, Indian companies may be mandated to have a different financial year. So they created a carve out and that carve out provided that you make an application to central government, and central government will allow on case basis to facilitate the consolidation in the respective jurisdiction. That was acceptable. Now, what has happened over a period of time? We will agree that there had been situations, not only the cases of seizing of these relationship as has been highlighted by CLC in their report, but there had been situations otherwise also. Like in 2015, we filed an application, we got the approval also. But now 5 years later, we are finding that this is even more cumbersome process, although it facilitates me in consolidating my holding company financial in US or UK or in other jurisdiction. But at the same time, it is causing me a burden also. So now 5 years later, management wants to revert back to the normal April to March financial year. Then there is a bottleneck coming, and companies were restricted to revert back to the original financial year, April to March. Or there are different practices. I can share the personal experience also. There had been approvals also. Even I can say we have got the approval also from the regional director in certain cases where we had shifted from April to March to January to December financial year, and then again we have shifted back to April to March financial year. Now, point that Ankit also has highlighted, why there be a need to revert back to the original financial year, because the government logic that CLC report has mentioned, that there can be certain benefits which are required to be given, or there can be certain deviations. So one deviation can be either your financial year can be of period less than 12 months, or it can be more than 12 months. That can be the only deviation. But in any case, that deviation is already permitted in case of newly incorporated company. So if I am a newly incorporated company, let's say if I incorporate in any financial year, in any year after 1st of January, then I'm allowed to close my financial year up to the next 31st March. So my period can be as long as 15 months for the newly incorporated companies also. So I'm saying that is not a point of contention where the government is having a conservative view that people will misuse this position. So I think I'll concur, if government is thinking to consider it as an ease of doing business point, then reverting back to the normal financial year should not be subjected to any approval. If at all government consider no, there is a requirement, they want to put some check, a reporting may in any case be there, so that necessary information is submitted to the government also in timely manner. And last point, what Ankit was also saying, that it should not be limited only for break of these relationships due to which the companies were allowed to follow a different financial year. It can be for any reason. It can be a sweet will, a decision of the management itself that they now want to shift back to the original financial year. Of course, too many back and forth changes should not be allowed. That's my point. That's my take on this particular provision.
Okay. So any other person, Madan, you have any additional point?
My humble submission is that no doubt I agree with Ankit and Amit both, that severing of the relationship is not mandatory. Even though the Indian company is willing to opt for financial year of April to March, it should be allowed. Number two, why was it taking time earlier? Earlier, one has to go to the NCLT for seeking this permission or approval. Later on, this jurisdiction was shifted from NCLT to central government, and I don't think central government should be taking that much of time. Third, that in case of if the government is proposing this particular relaxation, reverting back to the original financial year, and if the government is so clear that yes, an application has to be filed, first of all, I agree that no application is required to be filed, only a plain intimation should be sufficient, intimation by the concerned company to Ministry of Corporate Affairs or the ROC that we are reverting back to the April to March financial year. But if the government is of the view that an application required to be filed, I think a time period of 3 months should be given to the RD to grant this permission. And if within 3 months the permission is not granted, it should be treated as deemed permission.
Okay. Okay. Next point, Ankit.
I think Gaurav wanted to.
Gaurav, you want to say anything? Yeah.
Yeah, just one small point is that whenever there is change in the company structure where it is no more a subsidiary of a foreign company, in such cases, there is also no change in the sin of the company. So sin of the company remains the same, where it shows as a subsidiary of a foreign company. But I think so we can recommend this to the MCA that the sin should also be changed, that it is no more a foreign subsidiary, where there is a reference of FTC or PLC or PTC.
Correct.
Okay. Okay. Yeah, Ankit, next point. In the ease of doing business. Not changing. You have to unmute Ankit.
Now it's changing.
Yeah.
Okay. So next. Okay. So next is with respect to the law at certain places provides for submission of certain affidavits with respect to certain processes outlined under the Act. The proposed amendment tends to take away the requirement of submitting affidavits and replacing it by way of an undertaking. And there are certain provisions that have been outlined, but I foresee there are other provisions under the Act where also there are requirement of affidavits. As of now, those provisions, like for example, in case of shifting of registered office, there are requirements of submitting certain affidavits. So while some of them have been covered, but not all of them have been covered under the proposed changes. So a recommendation can be made to the government to consider other changes or other places also, unless and until there is a deliberate intention not to replace the affidavit with undertaking at those places.
Okay. So, Madan, you have any point in this?
I think the blanket provision should be there that wherever a declaration or well, now the government is distinguishing between a declaration or a affidavit actually is nothing but a self-declaration from the companies. If it is an affidavit, it's taken as an oath. So it should be provided in law wherever this sort of declaration is to be given to a tribunal or adjudicating authority or quasi-judicial authority, it should be in the form of affidavit. Otherwise, at all other places, it should be in the form of self-declaration. I think that one clarification will do. We need not repeat it where it is affidavit or where it is declaration.
Okay.
Yeah, I agree. They
I
have
think sorry.
Yeah, sorry, please, Manoj, go ahead.
Yeah, so I just wanted to say that in case of, let's say in case of a scheme of amalgamation, there is a requirement of, if we want exemption from the meeting of creditors, there is a specific requirement to have no objection in the form of affidavit to be submitted. So that is one of the biggest challenge because none of the bank or financial institution is willing to give their officers willing to give affidavit. So it is very difficult to seek no objection from them. They will give no objection on the plain paper with their authority, their letterhead. Similarly, there may be a lot of small creditors who are willing to give no objection, but obtaining affidavit is very difficult. So I think earlier position was there that the plain paper declaration was also allowed and considered for the purpose of exemption. So I think why to insist on affidavit in all the cases? It is not making any sense unless there is a question of fraud being made by some person or false declaration is being made by some person. So this type of flexibility should be there.
Manoj, in such cases, we may give a suggestion that the transferor or the transferring company may give an affidavit that we have received the no objections from all the stakeholders, maybe creditor, the shareholder.
That we are all anyway giving that company need to give and provide the list of the persons and their letter confirmation is also there. So obviously we have to relax that part.
But I tell you, one more suggestion we need to give. Amit, please. One more suggestion is to be there that across the NCLT benches, there should be uniform practices.
Yeah.
What I have faced couple of days before, only in case of this merger application, The affidavit does not talk about section 230 subsection 3 and blah blah. That's all. Name of the section is not there, but the contents of the affidavit are exactly the same. Now bench has asked to give a separate another affidavit, and the bench has given another date. So
Yes.
these practices should be uniform. This should also be one request from our side to ministry, and this directive should go from ministry to NCLT.
Yeah, I
Okay.
agree. I have just a small point to make a mention that government is perhaps doing these changes in parts. This is the first part where the declaration, where the affidavits which are required under the Companies Act in cases other than quasi-judicial bodies, that is NCLT and the other, they have shifted and allowed these affidavits to be replaced by the declarations. But in perhaps in the second phase, where the Manoj is coming from and what Madan sir also highlighted, maybe government will consider in the second phase that these quasi-judicial affidavits may also be replaced by the declarations. I think that would be the much bigger relief, if I can say so. I can understand the difficulty and the challenges what we face in the case of these restructuring transactions, basically. So I agree. But as of now, government intention is very clear that they wanted to exclude the quasi-judicial affidavits. Ankit, you can proceed, I think.
So next is with respect to provisions of restoration of the struck off companies. So currently there is a provision where a company has been struck off. Applicant can apply to the tribunal for restoring it within a period of 3 years. And there is also a provision of restoring it within a period of 20 years. So considering the burden on the tribunal as of now with CCI, IBBI and all other sort of cases, the CLC committee has recommended that this power of restoration in case of companies where the application is being made within 3 years of striking off shall be shifted from NCLT to regional director, and in case it is the application is made after 3 years but within a period of 20 years, then such powers shall continue to rest with the NCLT. So I think for the purpose of convenience, I think it will help a lot in terms of easing the process. Timelines may have some impact. I don't know what kind of impact it will have, but certainly tribunal is overburdened. There is no reason to doubt on it, and we are all aware of this fact. And I think people who are appearing on NCLT are better judged to provide their view on this.
Okay.
Yeah, absolutely, Ankit. I think it's a very welcome move, and it has been in demand for the last almost 3 to 4 years since the time the IBC, in fact, got started in NCLT. So a lot of time of benches is now occupied in resolving the issues relating to insolvency, which are definitely having much higher stake. So what Ankit has mentioned and what the CLC has also recommended, so there are two parts to it. There are requirement and there are provisions that under the provisions of 252(1), any person has the power to file an appeal against the order of strike off of the registrar, of the name of the company from the register. So that period is 3 years and any person can go. And this power is presently vested with the National Company Law Tribunal, which is now proposed to be shifted to regional director. It is certainly a welcome move, and majority of the companies would be benefited out of this particular provision itself. Now, second part of it is 252(3), where the only select category of person like company or its member or its creditor is allowed to file an application. However, time is longer. The time duration is 20 years. But you can file the application within the period of 20 years, and on the just and equitable ground also, you can seek the restoration of a company. So what I understand is even though the power would be with the RD, there would be certain cases where you find that the cases are to be restored on just and equitable ground, perhaps the NCLT would be better forum to file an application. That's my submission. I think Madan sir can submit.
Madan, your any view on this, because these companies strike off companies period. What is happening? The companies strike off, but there is some property asset in this company, and people are coming back. So it should be simplified with transparent procedure. What is your view?
You know, as Ankit said that IBC came in 2016, NCLT became overburdened, and in 2017, Ministry of Corporate Affairs through various ROC offices came out with a different notification, and more than 4 lakh companies' names were struck off. Now there is provision under Section 252, you file an appeal, thousands of appeals were filed. So NCLT, which was already overburdened with IBC work, was again overburdened with this 252 application. And I tell you, even as on date, number of applications which have been pending there, they have been pending for last more than 2 years in number of cases, because the clearance is not coming from ROC office as well as from income tax office. Every time they come, they seek time and they are granted dates. The court is actually, the tribunals are very liberal with ROC lawyers and income tax lawyers. Whenever they come, the dates are given. And the whole objective, the whole purpose is getting defeated of this restoration. So number one, I welcome this, that is a need of the hour. This jurisdiction should be shifted to regional director. Secondly, I'm of the view, why this 3 years period, why not all the cases should go to regional director? I'm of the why these cases should at all remain with NCLT. Because these are pretty routine matters. You know, you have to see the compliances, you have done the compliances or not. It's not a question of litigation that one should go to NCLT. Third, I'm of the view, particularly from the profession of company secretaries, actually 250 work, the majority of the 252 work actually went to lawyers. But now if it's shifted back to regional director, this work will also be shifted back to practicing company secretaries. So that way, I agree it's a welcome move, but I'm not in favor of 3 years. Even the 3 to 20 years also should also go to RD.
Okay.
And simultaneously, I'm of the view now if the work is with RD, the ROC reply will be fast now. Because ROC cannot afford to delay with the regional director. They can afford to have delays with the NCLT, but can't afford to have delays with the regional director. And ROC and NCLT, ROC and income tax, my suggestion, we can give this suggestion, there should be timelines that within this period, they have to give their NOC, otherwise it shall also be treated as a deemed no objection from their side.
Okay. Anybody wants to, I think this is a right move, and then we can reduce the burden. Friends, Ankit's son is not well. He has to hospitalize. So Ankit is just left. I will take care of his part. Yeah, Amit, you were saying something.
So I was just making a small mention, in current year Caro report as well as in the Schedule 3. Other day we were in discussion. I think R.K. Agrawal sir was also there on this particular issue. We were having a discussion. So point that was coming that now this year the companies are under an obligation to make a verification whether their company has done any transaction with any of the company which is struck off or not. Now, MCA has not provided any data as to which are the companies which are struck off, right? Although the data is provided, but that data is not in searchable format. That is PDF, which is unsearchable. Now, just imagine there are more than 5 lakh companies as on date, which are struck off, and you have to see whether the company has done a transaction with that company or not. How difficult is this particular exercise is to identify whether your company falls into that company or not. So government should provide a platform where you can just put a VLOOKUP check and or you can at least download the list in the Excel format. That is as simple as that. So that's an additional suggestion. Maybe from your forum, it can go to the government that may help the corporates in doing necessary compliances.
Okay. So next point, the three suggestions which Madan has given, that all should go to the RD and the 3 years period can be reduced, and then downloading the list which Amit has given, we will pass on. Next. Now, second is that government is already talking about the 398 provision related to filing application document inspection in electronic form. So they are proposing to do this. So, and the advantage is by doing this, payment of fees, e-enforcement, e-adjudication process will be simplified. So what is your view, Madan sir? If it is happening, then how the court burden will reduce, how the things will modify, and then e-adjudication process will be a automated process. What is your view?
It's more on papers rather than practice. I share with you my practical experience of all NCLT benches at Delhi and NCLAT. We are doing e-filing, but unless we file the physical files, unless we submit the physical file, the matter is not heard. Even a small affidavit we file, unless we submit the physical copy, the matter does not move at all. So in addition to electronic, we are filing physically, or we can say earlier we were filing physically, now we are filing electronically also, but physically still there is prevailing, despite all the provisions, all the infrastructure in place.
Okay, Amit, Gaurav,
I will, sorry.
Gaurav, you have any point in this? Okay, Amit.
So my point is that government has already made companies adjudication of penalties rules in 2014, and the rule were amended somewhere in 2017-18, and that has already provided for e-adjudication mechanism. Right, there is nothing which is now being talked as a new thing or new initiative. This is already there in place. Now, this is the proposal which is just a technical in nature, because section 398 has got one particular explanation which is coming as a roadblock to implementation of this particular provision regarding the e-adjudication, because certain peoples are interpreting it, though under section 400 government has power to make rule in respect of any of the provisions of the Companies Act for their implementation and enforcement. Now 398 is something which is specific to electronic digitization of the records, basically filing of forms and taking the forms on the record. So there they have created a carve out that government will not have a power to make rules to digitally impose the fine and penalty. I think that is where the restriction is coming. So government is now proposing to do away with this explanation so that they can move ahead with the e-adjudication of penalties. So e-adjudication of penalties is already, I think, in process, and platform is also ready. It should be announced and released in very near future. And I think that's a welcome suggestion.
Madan, in my opinion, what should be there, that all the technical violation which has no impact, which is not connected to the bigger fraud, bigger issues, that should be, because now so many violations are there where you have crossed the date. Okay, and then you have to go there. There is no question, nobody is asking. Only thing is you have to pay the penalty and things will be there. I think all these things should be like this. You have crossed the line, pay the penalty, they will issue the certificate immediately, and then your compliance is done. By doing this, the ROC and RD and the court can focus more on the effective thing than these things. Okay.
Can we call it faceless e-adjudication in line with?
It would be on the same line.
It will come on the same line, because there will be no face. You will not reporting to anybody. You have just pay the amount which is there. Okay. So now I'm moving to next item. These are the ease of doing business which they have done. Next is the investor protection and education. Now what they are proposing, first they are proposing amendment in section 124, that they are saying unpaid dividend. Okay. So they are talking about the all the amount which is there, all the security which is transferred, that amount should be there. Transfer to this. So any shares which is there and they have transferred to this, connected to all amount should go there. Madan sir, what is your view?
In my view, all these proposed amendments are clarificatory in nature. These should have been there earlier, but somehow or the other, these were missed earlier. Now it has come to the knowledge of the government, maybe by way of a feedback or suggestion, or through the CLC, that these should also be added back, and the government has done so. This is what my understanding of the plain reading of the
Gaurav, Anybody?
Sir, I think there is a big mistake what CLC has done in doing this amendment 124(5) basically. I'll explain a provision in a minute. See, the provision is that you declare dividend. Within 5 days, you transfer it to a separate bank account. Within 30 days from the date of declaration, the amount is paid. Whatever remains unpaid is transferred to the unpaid dividend account. And from that unpaid dividend account, whatever remains unpaid for 7 years,
Unclaimed.
goes to
Unclaimed.
unpaid, unclaimed, both. Unpaid, unclaimed.
No, we cannot call it unpaid. That is paid, but that is unclaimed. That's not unpaid.
Whatever way,
No,
I'm not going into that.
Unpaid and unclaimed both are different.
But law says unpaid, unclaimed, both. Whatever you could not pay, whatever you have paid, but it is not credited to the other's account, that is also falling in the same category. It will go to the unpaid dividend account only. And from unpaid dividend account, the money will be transferred to us, Investor Education Protection Fund after expiry of 7 years. Now, and there is one more provision, 124(6) says that any dividend which has remained unpaid for 7 consecutive financial years, the underlying shares will also be transferred to Investor Education Protection Fund. Now, government is saying we have done mistake in the past that we have not mandated to transfer the dividend for all the 6 years also, along with this particular transfer, right? When you have transferred the underlying shares, at the same time, you should transfer the dividend which is due on these underlying shares also. To best of my understanding, that understanding is not correct. That understanding is not correct because for these number of shares, the 7-year period will not have passed. For that period, let us say for 2015, dividend of rupees 100 which has remained unpaid, in 2022 you will transfer it to IEPF. For 2016 dividend, how you can transfer it today? Because 7 years has not passed. So I think it requires a revisiting. From my understanding, this is a misunderstood provision by CLC, and this recommendation should not go as it is.
No, Amit,
There is an issue.
I think what they are saying when 7 years is over, you are transferring that share. So they are saying when you are transferring any shares to IEPF account, then containing to that shares, any unpaid dividend is there, that will also go.
For subsequent, let's say A Limited has declared dividend in 2015, 16, 17, 18, 19, 20. So 7 years has passed today. Let's say I was holding 100 shares on 2015 and I got 100 rupee dividend, which has remained unpaid. So that will become due in 2020 to be transferred to IEPF. Maybe in next year, let's say 200 rupee dividend is declared. Are we saying that will also be transferred to IEPF?
Yes, this is the intention, because you have transferred the main shares in the IEPF. So whatever you are declaring, it has to go there.
Okay. I'll relook.
May I extend this question? Suppose the same example, 2015 dividend 100 rupees. I have not claimed it. But for the next year's dividend has been claimed by me. Now in the year 2022, whether that 100 rupees along with the shares, the corresponding shares will be transferred to IEPF during this year?
No.
So I'll tell you the reason of this. What is happening in IEPF, there is no tracking of this. Suppose you are claiming one dividend and then they are transferring to the IEPF. But in the process, some dividend is pending. So they are giving this clarification. Once you are transferring any shares to IEPF, whatever associated pending is there, you have to transfer. So the old amount, whatever amount is there, and the future amount, all has to come there in IEPF.
For future amount, there is already a provision in regulations, but as far as the outstanding on that particular date is concerned, I think yes, maybe government.
The point is, like after 7 years, you are transferring, somebody has not claimed. What about the dividend as declared? So when the IPF law came, previous to that, so many dividends were lying there in the company's account. So that also they are saying to transfer this. So in a way now it's very clear that whatever shares are transferring, it should entire thing connected to this present, past and future will go there. Okay. Next point is that is called the redemption amount towards unpaid or unclaimed preference shares. So we have seen that so many companies that they have come out with preference shares, and that is also having the same fate of the equity shares. So they are also trying that this amount should also be transferred. I think this is in the line. But one thing is very, I think, application money connected to some shares. Some company has came out with issue and somebody has paid the amount in application. That is also long back, it is going to the IEPF account. But how to identify, because I have not seen companies record where they are mentioning the application money they are transferring to IEPF account.
No, sir, these cases, as far as I remember, the cases where the IPO is done and the shares are not duly credited, these shares are transferred to respective registrar escrow account. They are not transferred to, I think there is a proposal, there is a request from the RTAs that these shares should also be allowed to be transferred to IEPF, which government has so far not provided. I think if you are talking about that, then that is a welcome move. I think that should be done. And even why only for this, there are many other situations also where the shares can be transferred similar to 124(6).
Yeah, Amit, I'm saying the same thing. If you are transferring, that shareholder is not traceable, he is not claiming. So whatever amount is due to the shareholder, whether it's a preference share, whether application money, whether it's a equity, whether it's a past dividend, all should transfer. So two things they have done. Other thing, which is shareholders fund, they should also transfer. Correct. Okay. Next. So this is just, they are talking about the giving power in the same line of IBVVI. I think this is a welcome move. Nothing is there. Next. So this is 125 section 125(2) and 3 allow unclaimed amount with respect to share brought back cancelled to be transferred to IPF. Now this is also very interesting point. Now what is happening? You have done buyback. You have cancelled some shares and that amount is lying there. So they are talking about, so in my opinion, it should be 360 now. Whatever amount is connected to that should transfer. So Amit or Madan, anybody can explain to this?
Yeah, I think I agree. This provision partially was already there in the regulations itself, in the rules itself, IEPF rules. Now they have extended it to certain other provisions also, to include the buyback and the other provisions also. So I think definitely it's a welcome move. The only thing is that is required is perhaps the old data is not very synced. So investors' experience of claiming the dividend or the shares back has so far not been very great. Government needs to work something very seriously on that if they want really, because I read the report, something total figure of 88,000 odd crores is lying with the authorities in respect of unclaimed figure. And we are not able to identify as to who are these people. So government need to invest. By now, why we can't create a common platform, common pool, where we give the work to one particular agency to identify as to who are these investors, rather than investors chasing the money. Why the regulator is not chasing the investors to deliver the money back to them? I think that's the need the regulator or government should now think about and invest some money to do some data mining and do some artificial intelligence to collaborate all RTS data, maybe they will be able to find out something good out of that.
Okay.
I think as Amit said, the process needs to be streamlined. It should be with the objective of ease of doing business. I share my practical experience. It has been 2 years. I received my shares back, but the dividend with respect to those shares are yet to be received by me.
Yeah, there are so many issues, not only Madan, that's why I'm saying something which is connected to you is credited to the company, that should go there in IPF. That's a simple point. Even by
That's okay. It should go there, but she should come back easily.
yeah,
Whenever the claimant is going there, after identifying the credentials of the claimant, it should be paid immediately.
Madan, the problem is that there are two types of people in this scenario. One is who knows about his shares. Second is those who are not aware. The number of knowing that I have a shares is very less. It's a 30%. 70% people are not aware, because you have purchased, your dadas has purchased, and they forget you are not aware. So that's why government has to do something to make it easy for claim.
So what Badan sir is saying, it is even difficult for the people who know that they own the share, but they are not able to claim it back. You are talking about one more degree of the problem.
Yeah, because the process is cumbersome.
Very cumbersome.
Okay, now friends, I'm moving to next chapter on this auditor. Okay, so Amit, Madan, and Gaurav, and Manoj, you can also add. Okay, now the NFRA, they are saying that if their professions are not following, then professional or other misconduct will be levied, and so they are empowering NFRA for this particular thing. Any issue in this?
First of all, I want to seek a clarification that what is the intention of the government according to my study, that if there is any violation of the Companies Act with respect to the auditors, this violation will be dealt by NFRA. And if there is any other professional misconduct outside Companies Act, that will be dealt by the Board of Disciplinary Committee of ICAI. Is my understanding right?
I think yes, that is the intent.
But if that be,
Then I will simplify this.
yeah,
Whatever disciplinary process was having these institution, it will go to NFRA and they will do it, and then they will.
no, it's not. I'm sorry, Pawanji, it's not like this, because the Board of Disciplinary Committee of ICAI is still there.
Yes.
If you the new Amendment Act of CSCS EMA Amendment Act, that's still giving the similar powers to all three BODs and disciplinary committees.
Right. Sir, auditors may be doing many of the misconducts with respect to, let's say, partnership firms audit or individual tax audit. For those violations, NFRA has no role to play because it is not part of their jurisdiction. So it will be only restricted to the misconduct with respect to any of the company.
So I think this amendment which is proposed at this point of time, the notification with respect to the CSCS Amendment Act was not there. So there seemed to be a conflict between this amendment and the CSCS Amendment Act. So probably taking that into consideration, this can be further, either it can be skipped or it can be further amended.
No, Gaurav, I don't think so. This is a report and report from the ministry, and that Amendment Act has also come from the ministry. Ministry is very well aware of these two things. I don't think there is any slip.
Mr. Murthy is the secretary in charge, and secretary is the chairman of this committee. So I think they are knowing everything, whatever proposal is there before Parliament.
But the way now the powers are being given to NFRA, even the power to make the regulations also, I think NFRA will be like SEBI or IBBI, where it is a regulator which can frame its own regulations. And looking at the previous scenario where we saw the differences between the NFRA chairman and other members of chairman, and all those differences were in open. So in such a scenario, whether such sweeping power should be given to the chairperson of NFRA and NFRA, I have my own observations or reservations on this.
We'll do separate webinar on NFRA separately time. Now the report is that 11,000 auditors have not filed NFRA 2 annual letter to be filed by auditor as per Rule 5 of NFRA. So they will get this power and they can issue notice to them. So this is one information to all for this. Next point is constitution NFRA fund with the administration of such fund. I think that is a just next point. So that is just simple point. So I think it's okay. Any so I'm not covering because there's so many other important interesting points are other there. Next point.
On this constitution of funds, Pawanji, I have my reservation on constitution of funds. Sometimes I've seen in the case of IBBI also they have been given authority to create their own fund. I mean, it looks like that the government is now creating these regulators and then saying regulator, you be self-sufficient and raise money for functioning of your own organization and officers, and that's not in the right spirit. I'm not in favor of such a provision.
But Madan, the point is how the government will fund that. So if they are funding so like SEBI and CCI and IBBI, they have made the rules and now these professionals they will manage. So through these professionals they will get the money.
No, but it's an additional burden on the professionals or the entity which are being governed by these regulators.
But actually,
you're asking the insolvency professional to share a particular amount of fee from their fee, whether you're receiving the fee or not. But whatever the fee is receivable, a particular percentage of that has to be deposited with IBBI.
Yeah, that's not in the right spirit. Regulators it should be acting as a government body, and yes. If they are government, then they should not be asking for hefty fees for everything. So that is not a right in the right direction. They are not business people, and that should not be the intent.
Okay, I think these are the separate discussion we require. So now next point. Yeah. Constitution of NFRA, that is also empower of NFRA to make regulation concerning specific matter like Companies Act. That is a only power they are giving. Next point. Appointment of auditors. Now this is interesting. Empower the CG to mandate joint audits for such companies as may be prescribed. So today, auditor appointment is by the company. It is their right. But now they are saying they can propose the mandatory joint audits. So how this liberty is taken away by will be taken away by the industry? What is your view? Gaurav, you have any view in this? Or anybody?
Yeah, I think it's a proposal which was enabling provision was already there. Many companies which were big, they were already having a provision regarding the joint audit. There is nothing new, but yes, now taking the examples and learnings from these corporates and especially the scams what had happened in the past. Government is now trying to create a mandatory provision for certain class of companies to have a joint audit provision, just to have a better check that one person may be easy to compromise than where the position is on dual responsibility. So I think that way, because it is going to be only on select class of company, I think it's a welcome move only to put an additional check on the company's governance framework. There is nothing wrong.
My take on this is that nowadays what my feeling is that majority of the amendments are coming on the basis of aberrations and exceptions. So that's not a healthy signal. If it's a need of the hour, need of the industry, please do the amendments. But out of 100 companies, if 2 companies, 3 companies have done something wrong, and then you prescribe something for all 100 companies, that is not in the right taste.
Yes, reactive amendments in law is not good anyway.
Because that's what is happening
that is happening in even by IBBI or SEBI, and all regulators are also doing the same. One mistake, one black sheep in the whole flow, and then they will amend the thing, which is not correct.
Okay, so now next is very interesting. Everybody should. Now what they are saying, removal, resignation of auditor and giving a special notice. So what they are saying, that resignation of auditor to make explicit disclosure about resignation. So today you can't say personal reason. You have to write, and that is also very interesting. They are saying not limited to disclosure concerning non-cooperation from the client, fraud or severe non-compliance or diversion of fund, as well as his assurance to the company's account and his decision to resignation. Now, this is very wide and very open.
I think, sir, this will open up Pandora's box. How without judging, without you are putting allegation against everyone. Many of the company would go for criminal defamation cases also against the auditors if they are putting this kind of things. They are not adjudication officer or judge. They cannot pass order that there is a diversion of fund or fraud. How they will prove it?
No, but I'll tell you the other side of so many times auditors are creating confusion and creating problem for the company. Yes. So that is also they are not resigning, they are doing something and they are arm twisting. So that is also both way it will be a.
And those are aberrations and exceptions.
Yes.
You know, if these disclosures are to be made by the auditor, to whom the disclosure shall be made? Will these disclosures be in the public domain? The moment disclosure are made, the image of the company is tarnished immediately.
Right. That is what I'm saying.
Yes.
For listed company, it is mandatory to attach that copy of resignation at the time of filing with the stock exchange, and it will be for public at large. So it will be pure defamation, and that will be done by the company itself, because they have to file it under Regulation 30 of LODR. So you are compelling to self-implication to companies. That is not at all workable.
Recently, we have seen 3 resignation letters from 3 independent directors. Each resignation letter is 7 pages each. Now, they have blamed everything. Nothing is right in the company. Neither the board, nor any committee, nor any corporate governance practice or norm. When they were there at the helm of affairs, everything was fine. All of a sudden, everything has gone wrong and you're submitting a detailed resignation letter. And what about the image of the company on such and such date?
Right.
So these provisions should be implemented introduced and implemented very carefully.
Very interestingly, they are saying if the auditor is not doing this, he will be penalized. So
yes, exactly.
So it is
every
double. Yes, it is not at all. I don't know. The committee has so many members who are professional lawyers. I don't know how they have advised this. They will open the Pandora's box, and after that, there will be criminal cases filed against those persons. I don't know what is the intent.
But I have read this UK Companies Act, where they are talking about this obligation, but they have given a protection to both sides. It is not one way. Here I am thinking it will be an arm twisting for the corporate, and the profession will also face problem if they want to resign from the company. Because you can resign for any reason. Now you are compelling me to write something against the company.
And if I don't write, I'll be penalized.
Yes.
Yeah. So basically, I feel this provision, which is applicable to listed companies, is made applicable to a very small company also. And I feel this is a very much a difficult amendment to implement, and has got no public repercussions of this. Means it will not be in public domain immediately, just as the case of a listed company. So I think probably MCA just wants the exact reason why he's resigning. Therefore, this provision would have been introduced.
Okay. So I'm now moving to next point, that is auditor not to render certain services. Now this is also very, though they have made it, but I mean, what is the need to allow and restrict? They have given the instruction now, you will not do other than audit work. Non-audit work is divided, audit work is divided. They have made, why they want to bring out amendment? Is there any?
Now, I think the intention is that because of the restrictions under 144 and without having a classification of companies, there was certain hardship which was being faced. There may be a big company, there may be a small company. If a company is small, the intention of the government seems to be little flexible in allowing the 144 services by the same auditor. But when it comes to a big company, they want a blanket ban and certain more stringent restrictions that auditor will be following. So I think I'll in a way say that this is a welcome move, that it will be based on more rational than putting a blanket ban as 144 is having today.
Okay, any other point?
So I feel that independence of auditor is important irrespective of the size of the company, whether it is a small company, private or public. So bifurcating the services of audit service and non-audit services not correct. I feel the existing section 144 needs to be implemented as the way it is right now, because conflict is created or independence is affected in any of the cases. So it's actually, I feel 144 is not properly implemented in the present situation. Therefore, such wayouts are being introduced with respect to the non-audit services.
Okay,
That's true.
friends.
Pawanji, what I read from here, from the summary which has been given in this report itself, it says that as the proposed amendment is going to restrict certain companies from availing non-audit services. It is not saying that auditors cannot provide non-audit services. It is going to restrict the companies to avail the non-audit services from the auditors. So it's a reverse mechanism.
मदान सर, आपको याद होगा कि जो 10 बजे के बाद सुप्रीम कोर्ट का ऑर्डर है कि स्पीकर आप डीजे और डिस्को नहीं करेंगे, पहले वो था पेनल्टी लगाने का सिस्टम ऑन द पार्टी हु इज कंडक्टिंग द पार्टी. Now they have put in this condition to the DJ वाला कि आपका सामान कॉन्फ़िगरेट कर लिया जाएगा. जिस दिन से ये हुआ लॉ, उस दिन के बाद क्या हुआ? Everybody has done. TDS is also same thing. That TDS you have to deduct. So same thing they are saying. It is not the auditor has to see. You have to check as a company whether that person, because sometimes what you are doing, you are taking services of the auditor in other companies. So you have to take a call on this issue. I think in place of auditor, they are putting this condition on the company. So this is one important point as they have mentioned. Next point. Punishment of contravention. Amit, any point in this which you think it is and it was an anomaly which has ratified?
I think I have not read this particular provision as to what is the implication, but
simply what was the earlier the punishment of contravention of section 143, except for contravention 143(12), which is covered in 143(15). To ratify this anomaly, they have suitably amendment they have made in 147. So entire issue is clarified, no confusion. I think this is a clarificatory thing. Not much.
Earlier, I think the penalty for 143(12) was up to 25 lakhs of rupees.
Yeah.
So if I remember correctly, 143(12) deals with the disclosure by the auditors of any fraud being committed or which has been committed. And for that, up to 25 lakhs, I don't remember right now whether it's a fine or penalty. But okay. It cannot be. 25 lakhs cannot be penalty. It has to be fine only.
Okay, friends. We have more than 27 questions are there. 27. We have covered only 8. So we have to be little bit faster now. And then something which is bigger in nature. Now forensic audit. Now what they are suggesting that presently forensic audit is doing with a specific instruction of the regulator. Now they are saying in particular circumstances or investigation, forensic audit is compulsory. So that is they are proposing. So I think that is just when the rules will come and the things will come. So the message they are saying, if there is any investigation and any particular type of things happening, you have to follow the forensic audit.
But Pawanji, let me share with you that during last 3-4 years, I have gone through more than 100 such forensic reports, particularly which have been given under IBC. All those forensic reports have been with disclaimers and are of no use at all. They are also simply saying this is for the purposes of the person who is obtaining it and cannot be produced in the court of law. But so many disclaimers are there and you can't take advantage of those forensic reports.
The point is forensic audit institution is not developed in India, and the concept of forensic audit is directly connected with technological knowledge also, because today you are meaning. So India has to go a long way for doing forensic audits. So today, whoever is doing this work, he is also fearful that whether I'm doing right or wrong, because he is also not clear on certain aspects. So I think this particular institution has to develop more training, more programs, more knowledge they have to provide.
I
But
think
that should be done before you introduce some provisions.
But
That's-
the forensic audit is there already, so that's why I think you are right that institution has to develop.
Yes.
Okay.
this provision is more a enabling provision to facilitate the government officers to pass orders for doing the forensic audit during inspection and investigation.
Amit, no. Now they are saying CLC recommended that forensic audit may be ordered during investigations
That
of
is what I'm saying.
and may be prescribed. So
Yeah.
they will give a blanket that this type of investigation you have to go forensic audit also.
So it's an enabling provision for the government people only. Nobody means company itself will not conduct a forensic audit.
Next. Now this is interesting, that standardization qualification for the auditor. I remember earlier what was happening. Auditors were giving their comments. Now in the CARO, they have made that annual report or the auditor's report will contain on the last page in italic whatever your negative comments. So I think this is also a good move, that they should write clearly, because half empty, half full glass you can write in any way. So they want to plug that loopholes, and they want to say that adverse reservation, all remark, your financial statement should be collaborated and it should mention properly.
My one suggestion is, observation, whether the impact statement should come from the person who is giving the adverse remarks. Should it come from him only, or should it come from somebody else?
No, I think, Madan, that will be a cumbersome. Auditor,
Like in CSR, we are doing the impact assessment. Now, who is doing the impact assessment? How should it be done? Should it be outsourced, or internal people only should do it?
far reaching, because auditor has to give. So first they will do this. After that, because auditor's work, you are saying some other person should do the impact assessment.
But I tell you, if the auditor is given this authority to give impact assessment also, in majority of his cases, they may not give the adverse statement or adverse observations.
No, what is the problem? If he's not giving, then he will face the consequences.
And we can discuss it a little bit later on.
Oh, okay.
Yeah, sir, I have one more point in this. If we see section 143, subsection 14, it says that this provision will apply to even cost audit and secretarial audit. So the provisions of standardizing the qualifications will apply even to the secretarial audit also as well. So it has an impact on the other professions as well.
Yeah.
And their audit.
Yeah, Madan, it is just liking that you are saying the companies they are not maintaining properly. Now this word is also, you have covered everything, but if I'm not maintained properly, what will be the impact? So that will, I think that is good for the corporate world. Today auditor is writing something and they are creating anything, any negative comments can create any problem. So that's why they are saying you have to write the impact, whether it's impact is small or impact is bigger one. Suppose I have done one transaction which is wrong of 1 lakh rupees when my balance sheet is 100 crore. So he's saying that they have done this. So impact assessment will help corporate. It will be a good for the companies, and auditor cannot manipulate it for their own benefit.
Now, maybe because of this provision, the secretarial audit fees will be very, very respectable now. I'm sure, because of this new proposed amendment.
Maybe. Okay. Now come to the next point. That's the corporate governance. So in the corporate governance, first they are setting up the risk management committee. Okay. So Gaurav, you have any view that risk management?
Yeah.
Though it is recommended, but now they are making a mandatory. So in certain companies, will it be?
Yeah. Yes, sir. Actually, risk management references are there in quite a few places in the Companies Act, including the board's report. But now they are actually having a formal committee under the company law. This is already there under the SEBI regulation. So mostly it will be obviously applicable to the public companies. If the applicability of this will be similar to the audit committee and the remuneration committee, then there will be uniformity in the application of all these provisions. So yes, it's a welcome move, because now it's just implementing the committee related provisions.
So, but everybody should understand this point also. That
Yeah.
After the COVID and after this Ukraine war, China, and after the China fiasco, so three things has taken place in the world. So everybody is realizing that you are doing good business, no problem. But whenever your business will be go away in one shot, you are not aware. Suppose I'm exporting entire thing to the Ukraine. What happened to it now? So my entire business will go away. So I think the risk management committee which is there, their mandate that how much business you are doing, if there is any problem, what will you do? If US impose any restriction in India, so what is your business? That is majority of this. So I think this is the right move, and they should come out with clear guidance that how and what are the risks you will cover. Otherwise, there will be confusion. Small risk, people will make it bigger one.
A small observation on this, that its report says that RMC as a separate committee of the board. In my observation, as in under LODR also, RMC is not a board committee. It's a statutory committee, but it's not a board committee. So here they should also desist away from making it a board committee.
Okay, that's a good point. We can note down this. Okay.
आपने सिखाया second standard board में.
Yeah. Next point. The next point is section 164 related to disqualification vacation of director. So now they are proposing that the vacation of directorship under 167(1)(a) should be limited only to disqualification triggered by reason of personal incapacity and not incurred under section 164(2). So Amit, your view.
I think it's a long pending demand from the government, not from today. In fact, when this provision came on 1/4/2014, we were even discussing whether 167 disqualifications and vacation include 164(1) or 164(2) also. So that time also there was a debate whether 164(2) is a personal incapacity or it is relating to some other company's incapacity. Good that government has realized maybe after 7 years that that's not correct proposition, because it is having a spiraling effect, which government has seen also in the past disqualification regime. Ultimately, it has not benefited. It has burdened the administrative machinery and the judicial machinery only. So I think a step in a right direction, whatever learning we have made out of that, and government has now clarified that it no longer will remain a point of vacation of office, and disqualification will be limited with regard to vacation will be limited to 164(1). And I think, yes, it's
okay,
in the right direction.
Okay, next is vacation of office of director. So now they are saying 6 months to 2 years of freshly appointed. So Gaurav, any view on this?
Yeah, actually there are still practical issues in resolving the compliance and all the matters in relation to the defaulting company exactly within a period of 6 months. So therefore they have extended, they are proposing to 2 years. 2 years is also very high, but yes, within that time they have to ensure the compliance for the company. But yes, so this is also, you can say, considering the practical issues in implementing within a period of 6 months.
Because expecting a company which was in default in payment of interest and debentures for continuous period of last 3 years, right? And now all of a sudden you are saying ki in 6 months time you will be resolving the default and you will be setting the payments is very, very impractical. I think,
So I think
2 years is also not very justified, but yes, at least we can say it's better than what 6 month period was providing.
okay. Next is the nominee director. Next is disqualification of appointment of director. Now they are saying it will not applicable to nominee director appointed by debenture trustee registered with SEBI. So
yeah,
what,
I think it is related to specifically only one particular provision where the debenture trustees are appointing a nominee directors. So the companies and they were appointing a nominee director only in cases where the default were there. Where default were not there, the nominee directors were not appointed. And the moment nominee directors were appointed, they were apprehensive and they were resigning from the board position because the disqualification was triggering to them, and they have to vacate from all other companies also.
Amit, they are talking about the debenture trustee registered with SEBI. They are not talking the nominee director of other, like they.
Yeah, I'm talking about that only. So if I have issued the debentures which are falling under the radar of this particular framework where debenture trustee regulations are applicable, and where I have done a default, the provision is that I'll be appointing a debenture trust nominee on the board of the respective company. So these nominees were also suffering from disqualification and vacation. So now limited change that they are saying कि you create a carve out for them, and 164 2B disqualification will not trigger to them.
Okay.
का कहना ये है, this provision should be extended to, this election should be extended to all nominee directors.
All nominees, yes.
And not restricted to debenture trustee nominees only.
Yeah.
Next. LLP Act amendment to this is also provision disqualification vacation of director's office. So amendment to LLP Act through notification under section 67. So I think this is
very similar provision. What we had discussed for companies has now been extended to the LLPs also. So if you continue and if you incur any such type of disqualification, but now because 164 and 167 provision has already been amended. So I think the challenges what we were facing in respect of companies will also be relaxed for the limited liability partnership also. So
okay. Next, that is also clarification, the cooling off period before auditor become director. So 1 year.
Yeah, 1 year.
The cooling off period before auditors becoming the directors. So any view in this?
Okay, now Companies Act is going to be in line with LODR.
LODR, yeah.
Yes.
Yeah. So that is also okay. Next, company to have board of directors. This is clarifying the tenure of the independent director. So
actually,
now,
through this amendment, now they have clarified that independent director can be appointed as an additional director by the board.
And that will not be considered as one separate tenure.
Yes. So,
but they will.
We were having discussion for last 4 or 5 years. Now all the discussion coming to a rest and the clarity.
But Amit, tenure will not be counted, but the number of year will be counted.
No, so that, absolutely. So from the date of appointment as an additional director to the date of general meeting will be included in the total tenure, but that will not be considered as one tenure.
But Amit, don't you think there should be consequential amendment in section 149 which says the independent director shall be appointed by the shareholders in general meeting?
So I think that's a larger debate, and we have not been able to.
No, it is admission of the fact. This proposed amendment, admission of the fact that independent director can be appointed by the board as additional director.
Yes, that's a admitted fact. No
Okay.
doubt about that.
Okay, next, to provide the so in Amit, I should conclude your point. Earlier, they were counting even 1 year as a tenure. Okay, suppose you are appointed for 5 years to 5 years, that is 2 tenure, but you are appointed for 1 year for 1, and then again you are appointed for 5 years, so 6 years, but they were counting as a 2 tenure. Is it right? So
Yes.
now what they are saying, if you are appointed as an additional director and then again you are confirmed for the full-time director, that will not be counted as a tenure. That will be treated as 1 tenure,
Correct.
but your years will be counted. Okay?
Correct, absolutely.
Okay, next, to provide that to introduce 5% threshold to cap the maximum revenue that may be generated by a legal or consulting firm in certain circumstances.
I think
So now-
Madan sir can answer.
Madan sir, what is your view? I'm totally opposed for this independence of 5%.
मतलब पहले 10 था, अब 10 से 5 करने जा रहे हो.
हाँ. So,
Actually, कुछ ऐसे cases आए होंगे, practical examples आए होंगे, why they want to target professionals here only. But I am always view common, if a firm is getting its 10% revenue from a particular entity, Do you think any individual from that firm can be called as independent director?
In my opinion, no. Anybody who is doing any work, I'm saying any work, not as a percentage. Any work who is doing, his independence is compromised.
No, that's also not the case if you are applying the principles of ordinary course of business and arm's length, and those principles, if somebody is fitting into those principles.
Madan, what is the arm's length? Suppose you and Amit are competing with my company to get the work. You are independent director, okay? And Amit is trying to get this work. Amit will not get work because you are inside. Whatever arm's length you are doing.
Then the similar principle is applicable in case of related party transactions also. There we are allowing all related party transactions in the ordinary course and our arm's length.
Related party transaction is a things which is coming out from inside, and they are saying related party can do transaction subject to that you are doing business. It should be arm's length on the same rate which is providing to the market or which is getting into the market. They have to do one test for related party. Whatever your related party is providing, if I'm going out, I will not be paying less or I will not be charged more. That's a simple point.
But same test is applicable here also in case of independent director. They are applying the similar test here.
Madan, you and your son is a related party, but I'm not your related party. I'm coming to your company, and I'm on the mercy of you. So I can compromise my independence, because if I'm not towing your line, you can remove me.
So now let's confine to this proposed amendment. They are saying 10 to 5. You are saying it should be 10 to 0. I will say it should remain 10. We are having different views on this.
Okay. Next point. Appointment of MD, a whole-time director or manager, to provide a cooling period of 1 year for ID to become MD, the whole-time or manager in the same company. So now they are saying there's no restriction earlier. Now, today they want to put a restriction of 1 year. So what is your call, Gaurav?
So this is again in line with SEBI LODR recent amendment. So at least we are aligning company law and the SEBI on this part, so it's good.
Okay. Next point. That is also insertion of new section under chapter appointment of remuneration of managerial person in case where the company fails to intimate to ROC within 30 days. The KMP should be allowed to file their resignation directly to ROC, like same with the company secretary. They are proposing this and the director. I think this is a welcome move.
A lot of KMPs were facing a lot of harassment and their forms were not getting filed, and companies were going into prosecutions and all, so they had to unnecessarily face the consequences. So I think it's a great move that something on similar line, DIR 12 can now be filed for the KMPs also.
Okay.
I have one more suggestion here. That appointment of KMP is UPSI. So if a KMP is resigning, I think the provisions of independent directors under LODR should be inserted here also, that in the resignation letter, the reasons of resignation should also be mentioned. And again, a confirmation that above are the only reasons and there is no other material reason.
Okay. Okay. So, next topic is technology and IT. So Gaurav, facilitating communication in electronic form. What is the call?
So this is a very welcome move, and we have been experiencing for last 2 years with respect to serving the documents on the at least the shareholders minimum. But here they have given an option that they can also ask for a physical copy to the company, which was also the case earlier. So yes, this green initiative and e-initiative is now being properly implemented through the Act. So cost effective and convenient mode of serving the documents, I feel.
But they allow companies to stipulate the consent fees at general meeting. It is a very cumbersome, I think, confusing provision. Government can prescribe the direction. Every time in the AGM, you have to explain. I don't think this particular thing is irrelevant nowadays. Or government can fix this. Why you are giving to all companies, they are coming out their own logic.
Right. So actually,
if at all you want to fix the physical charges for the any particular mode or for the physical, then only it is required. Otherwise, it is not required.
Okay. Okay. Next very important point. The relating general meeting. Now they are talking about the holding AGM electronic mode in such manner as may be prescribed, EGM and general meeting. So today there is they have taken advantage, or they have tested the good part of electronic general meetings in Corona period. So they want to continue this. So I think this is a good move. Anything against the electronic mode meeting? Anybody who want to say that electronic mode meeting is not good?
Actually, I've been saying it for last more than a year now that all these relaxations are going to be permanent feature of the legislation now, and that is coming now.
Okay, Amit, any negative part of electronic meeting?
No, only caution is that government has to do some stringent checking that these provisions are not to be misused for settling their corporate disputes, basically. Otherwise, these provisions are all okay. There are necessary enablements where the checks are already there. But yes, there had been cases in the past also where these provisions have been misused to the benefit they are settling their corporate dispute. Otherwise, it is all welcome.
But what are the corporate disputes? What
Amit, if you can propose something like this, that in a smaller companies or maybe private limited companies, the meeting shall be in physical mode. However, a person who is willing to attend a meeting in a virtual mode will be given an option. So that way, your issue, your observation may be taken care of.
But sir, that option is already
that option is already there.
That already there by providing hybrid facility. Now, till now, we were experiencing 100% physical meeting or 100% virtual meeting. But now there is a provision which CLC is recommending that we can go with hybrid mode also. That will be something new, which the rules will say. But again, as GP Madan said earlier, that they are creating class of companies every time. So it's applicable to certain class of companies. That is the, what class of companies they say, that whether it is listed company. So private companies and subsidiaries become a very small part of it.
Okay, I'll tell you the interesting point. Because you are doing the physical meeting, which is allowed. So if they don't want to call the shareholders, they are calling physical meeting. So in my opinion, the best thing is that companies should be allowed to do hybrid meetings. If they are doing physical meeting, then they should provide the hybrid mechanism to the shareholders also, because we have seen the larger participation in this. So government should modify this, that you can do e-meetings, but if you are doing physical meeting, you have to provide the e-meeting facility also.
Absolutely.
Okay. So it can be larger participation. Next. Maintenance and inspection of document in electronic form. Now this is one changes in section 120. It will create that all the professional and the companies, those who are managing this affair, they should understand the entire gambit of the electronic process. So this is a good move, but certain issues are there, compliance cost and other things. So what is your call on Gaurav?
Sir, I think I have been advocating this change for the almost last 7 years. I had been saying that now, since Companies Act already has necessary provisions with regard to digital maintenance, Companies Act 2013, and why not government itself comes forward by giving a platform, and because whatever forms we are filing like DIR 12 or SS7 or PS3, all majority of the statutory registers are already automated. They are auto-filled. So you just need to create a platform and all returns will be auto-populated. Now government is going to do is maybe they will be charging certain fees and services. A platform will be created and the data feed will be taken from the MCA portal itself and returns will be auto-populated. and you will be only allowed to give a confirmation and do certain modifications in the case you require for filling certain data and information. There will be certain fields where the modification will be allowed. There will be certain fields the modification will not be allowed. That is what I understand. So it's absolutely fantastic move, and will be a boon for the true digitization, where you will be able to do the inspections also. Practically, shareholder today is not doing or is not able to do the inspection because he cannot travel to that particular location. But now the digital documents are available. He can make a request and he can make the inspection of that document also. So it's going to be a very revolutionary, I'll say, one big change after last so many years, I'll say. Means
Okay. Now, friends,
sorry. So one point, in all this electronic mode, in Companies Act 2013, there is no provision for destruction of records. In fact, when they are bringing this electronic part, they need to introduce the provision with respect to destruction of record, which we had in 1956 Act. So, because it may happen, obviously, that the physical registers we have to transfer it to the electronic mode and dispose now as well. So we need to have the rules like that, and they need to bifurcate between what is the permanent record which was there earlier and what is you can say what can be disposed and how they can be disposed.
Is saying it, earlier you were having a problem to hold the records in the physical form. You require place. So now they are saying you have to just use a small hard disk and put all the records. So there is a possibility the government will start saying that if the company is starting, then there's no problem. You have to maintain the records.
no, I think Gaurav is saying a different point, sir. Gaurav is saying ki because they have provided a mandatory provision for making transition from physical to digital. So when we will completely transition from physical to digital, how to destruct the physical record? I think he's on that point. Is that right, Gaurav?
Right.
Yes. Yeah.
So I think, yes, very valid point. Government need to, I think when the rule will come, all these things, when the law amendment will come, these things will be taken care of. But
Yes.
good that you have highlighted. I'm sure government will become little more sensitive to this particular point.
So you have to coordinate with both of them. Okay, now comes some amendment relating to the capital market. In the capital market, they have recognized the issuance of holding of fractional shares, number one. Okay, so Manoj, fractional share, what will be the impact? Because today what is happening, you have a 1 rupee shares minimum, 1, 2, 5, 6, up to 10, 100, 1000.
That is the, yeah, sir. So that is the face value. Now they are saying that in case the face value is ₹10, but the market price of share is, let's say, ₹500, and you want to buy only 20% of that market price, that should be allowed. But that is obviously with respect to listed companies. Here they are talking about issuance of fractional share due to certain transactions like mergers, amalgamation, or maybe bonus or rights issue where fraction shares are being created. So they are now saying that those in those circumstances, if the company is issuing new share, they should be allowed to issue fractional share to the persons who are entitled for a fractional share. Now, but I don't know why they have also written that except in case of any corporate action. So whether they are talking about corporate action covers merger, amalgamation only, or bonus and split or rights would also be considered corporate action, then what will be the purpose of this amendment? I don't know. And for listed companies, they are saying that this will be in consultation with the SEBI. So SEBI is also considering this, that was in news also, that they are considering sale purchase of fractional shares. So that will be a good move. If that is allowed, that will be a very good move. There are certain companies which shares are very high priced, and persons might be willing to take fraction of that. So if that is tradable, then obviously market liquidity will improve, and that will be a good thing.
And this is applicable in other part of the world also.
Yes,
but
many of the countries have this type of.
Dematerialization.
Obviously, due to dematerialization only this is possible.
Adnan sir, you are expert in capital market. By
I'm saying when you can deal in cryptocurrency, the why not in fraction shares?
Why not? Yes.
Okay. Next, Mohini, the recognition, issuance of holding of fractional shares after that, restricting stock unit and stock appreciation right. Friends, you are aware that SEBI is allowing SAR and RSU, but Companies Act is silent on ESOP. So they are proposing that because of so many changes are taking place in compensation scheme, gig workers are coming, various other people are coming, new types of employment is coming other than permanent, and this type of thing is SEBI has prescribed. So Companies Act is also recognizing this. So Moini, what is your take on this?
I think Moni, you are mute.
Now I am audible.
Yeah.
So already SEBI has recognized SAR in 2014 guidelines itself. And with respect to the RSU, so in 2021, they have already recognized RSUs that it is a kind of an ESOP only. So it's good that now the Companies Act also consider both these options in this Companies Act as well. So presently, if RSU or SAR need to be given, then in that case, we have to follow whatever the ESOP guidelines presently of Companies Act talks about. So now if it is being separately be described and a proper norms and terms and condition will be given, it will be good. And it's requested that whenever the guidelines will be framed, it will be as per the minimum guidelines with respect to the ESOP or mentioned in the SEBI regulations. That will be great if both are being aligned in the same manner. The other thing which I want to raise a concern here is that in the RSU and SAR, they are talking about that RSU is when the shares get vested, immediately when get vested, get credited in the employee, like a share. And similarly in the SAR, they are saying that an entire appreciation will be paid in the form of a share. So that means the question is that because in the ESOP, the employee need to exercise and have to pay something for exercising those ESOPs. So whether in the SAR or RSU, if it being implemented in the company, then the company, as per the Companies Act, whether it will be entirely be compensated to the compensation cost and the employee will not be going to pay anything. So it requires a clarity that how, because a discount as only sweat is the there wherein the security issuance can be done on a discount or lower than the nothing to be received. But in the other than no other instrument is there where nothing to be received. So whether in the RSU or SAR, same kind of some consideration will come or not. So that will need to be taken care of, and the government should take care of that, whether the things can be incorporated on the front of this consideration which the employee will be paying. So as they are amending the other point other than RSU and SAR is that if the Company Act is going to be taken care of all these employee related points, then there is a one more point like ESPS, which is not being defined under the Companies Act altogether, but they have been mentioned and covered under section 42 that yes, ESPS, that preferential offer means which does not include any ESPS, employee stock purchase scheme. But if we read the entire Companies Act, there is no particular section or no terms and conditions are there which a company need to follow to give the ESPS. ESPS is a well recognized term in the SEBI Act, wherein the SEBI laws are giving that it's an offer, it's a directly offer of shares. But if whether we fall it into ESOP, then it becomes an option. It will not be an offer of share. And preferential offer is not also be applicable on this ESPS. So how the ESPS will be going to be issued in an unlisted company? So it will be a question mark when you are recognizing this. So you requested to consider this as well, that how the ESPS can be governed under this company. And another thing which I think under the employee stock option, the important this RSU and SAR, whatever the mode we are giving, it is a part of a managerial remuneration of the directors. So directors' managerial remuneration include a value of the perquisite in the form of whatever the benefit they are getting out of this RSU, SAR or ESOPs. So what exactly the value of it will be included under the managerial remuneration, that is the purview of the Companies Act. And as per the Companies Act, we have to link with the Income Tax Act. So there is no parity that what exactly the value to be included under the MR. So if that clarity can be come upon, so that will be great. So these are the main important points which other than this RSU and SAR can be considered by the committee, so that a more clarity will come into picture for this. And including that, as the sir said, that SEBI has recognized many other type of employees as well in this ESOP. So to align and to give a boost to the startups and all, the committee should also consider that part as well for the employees as well.
Okay, thank you, Mohini.
पवन जी, आपने और मोहिनी ने तो डॉक्टरेट की हुई है ESOP, SAR and SAR and all that. You know, ordinary professional doesn't understand these terms even as on date. So my humble request would be, there is a question also in the question answer box, the Q&A box.
Okay, Mohini, quickly, in a minute, just make it.
अभी I think मत करिए, उसके लिए separate program करिए. Actually, what exactly the distinction between ESOP, RSU and SAR, or they are one and the same thing? What is the vesting and what is the tax implication of these three?
Okay, we will discuss this issue separately, and we are planning to organize a program on ESOP where we can discuss each and every aspects of this, including sweat equity. Okay.
Rather encourage the employers also to come out with these schemes.
Yes, that we will discuss. Achha, now friends, I have only 10 minutes and I have a 10 question and so many things. So I'm asking the respective person, quickly he should give answer. Manoj, prohibition of issue of shares at discount. It was a earlier shares you can't discount, give in discount, but now stress asset shares you can give discount. Any take on this? Any issues?
Sir, I think it is enabling provision, and that too they are restricting to certain class of companies, certain class of entities to whom it will be allotted. Maybe they are saying central government, state government, and such other class. So that will be banks and financial institutions. They will be maybe issued shares at a discount at the value, fair value determined by registered valuer. So I think that's fine. Even I think for other persons also, in case of distressed companies, it may be allowed. That would be a good idea, like in earlier days.
I think it is going to be extension of the existing provisions, because existing provisions also allow issue of shares at discount in case of a corporate debt restructuring scheme or all that.
Yeah.
Okay. So now next point is the company purchases own securities. This is buyback of shares. Manoj, the explain free reserve. I think.
So I think there was a bit confusion because of the proviso to section 168(2)(c). In the beginning, it is talking 25% of the share capital and free reserve to be utilized for the buyback. That is the maximum limit. The proviso said in case of equity buyback scheme, the limit shall be calculated based on the equity shares, 25% of the equity share capital as on the date of capital. So obviously free reserve was missed out. So it was a confusion whether only 25% value of the equity can be used for the purpose of buying back. But practically it was not happening. It was everyone was taking 25% of the equity share capital and free reserve collectively for determining the consideration. Alternatively, we were also thinking that it is the old section which was talking about cancellation of not more than 25% of the equity in one financial year. So that was interpretational issues. So they want to just plug that gap, I think. Amit may be a better position to.
Yeah, I think I have a completely different view. Perhaps CLC has misunderstood, and this clarification may be superfluous because this confusion was never there. 68 section where it was talking about, I'll just read the provision. It was saying that the buyback is 25% or less of the aggregate of the paid up capital and free reserve of the company. This is a provision. And then proviso is that provided that in respect of buyback of equity share in any financial year, the reference to 25% in this clause shall be construed with respect to its total paid up equity capital in that financial year. So how I interpret is the company may have equity capital and preference share capital. So they have created by virtue of this proviso that if you have a equity as well as preference, then 25% has to be restricted to equity only. You cannot extend 25% of equity plus preference. But at the cost of preference, you cannot buy back. I think that was the
That
intent.
was the intent of the existing law. Yes.
Exactly. Free reserve was always a part of total corpus of 25%. There was never a confusion. Me and you have done several buyback, and all corporates are also doing. So I think this clarification is giving a understanding that those people who have added a free reserve in the past, they have done something wrong. No. I don't think that is the intention. The clarification which is required is basically on one point, whether there is a restriction on 25% of number of shares also or not. Which to my mind
was earlier in 77A of old company.
Because there is a now clear distinction in departure to 77. Now under 68, language is very different. So there is no restriction as such on the number of shares. Now only restriction is that your total buyback payout should not be more than 25% of paid up capital plus free reserve.
Yes.
Okay.
That clarification should come.
Okay. Now next is please change it. Okay.
So I think this is also an additional provision where they have clarified that option buyback will be allowed only after they have exercised, which is okay. I think Mohini has.
I think unless it is created, unless the option is converted into equity, no buyback provision can be implemented. So that's, I think, correct clarificatory thing. Nothing.
But Manoj, in the SEBI, if we go, so they have also now considering the buyback of the ESOPs as well, like the options. Your specified security includes ESOPs as well. So already, only the categorization, once it is exercised, that means it's a particular category of the specified security holders. They will be given the buyback.
That is the
once
section
they are converted into equity.
Section is also providing that ESOP can also be a scheme of buyback can be framed for buying the shares from employees. So they are saying vested options and exercised options may be bought back.
But not vested. They are not talking. But in the companies, they are not only talking. They are not talking about the vested options. They are saying that once it is exercised, then only it becomes the shares, and after shares, then it can be buyback.
Yes. Obviously, cancellation of capital may not be required in case there is only
yes.
option.
So that's the reason I think they are not considering the option buyback under the law.
So under SEBI law, Mohini, are you saying there is no restriction?
They have given the committee a power that they can design for the ESOP buyback as well.
So options buyback is permitted under SEBI law, but under
SEBI, SBB regulations, yes.
Yeah, correct. But under the Companies Act now, as per this proposal, the clarification will come and we will be restricted. We cannot.
We will be restricted. Yes, then it might.
I think it is out of the purview of the Companies Act or buyback section. If it is not a share, if it is not a share or securities, it is just an option. Then it is just a matter of remuneration being paid to employee by whatever means it may be. So it is more like SARs
compensation
or
being paid. It's a kind of a settlement of a company.
Right, like the market price of the company share goes, so you will be paid X amount. This is monetary.
Why this restriction do you think is required? To my mind, it is superfluous, not required.
It is just a clarificatory thing that when share is created, then only buyback can be done.
Yeah.
Amit, what is happening? There is now the unlisted companies are giving ESOP. And what is happening when they are giving ESOP, then the company people are asking what is the advantage of this ESOP. So companies are ready to buy back. So the provision of buyback of ESOP is there for a listed company also. Then it means I am giving you ESOP, and after 3 years I will buy back. So you will get exit. So I think this is a right move, which is there.
That we understand.
No, they are restricting it now. They are making it clear that you have to first subscribe to the share, and then only you can tender in the buyback. That is
not be there.
Per se, ESOP instrument cannot be exchanged as per this.
Option cannot be surrendered.
Option cannot be surrendered.
Next point. We have more point now. Merger. Manoj, very quickly you have to tell in the merger. Now the treasury stock which was they have discontinued.
Right.
But earlier treasury issued before 2013 was lying there. So now they are saying that is also extinguished. So what is a
Yeah, so 3 years time has been given for all the companies who have treasury stocks to either dispose of in the market, or otherwise they have to get it written off in the form of reduction of capital. So that, I think, logic they have given that this is against the governance norms and others, but practical difficulty might be there, like in case of even only in case of Reliance, the value of treasury stock is more than 1,15,000 crore rupees. So if they want to dispose them off, then there will be it will be about 20 IPOs money will go against those shares. So practically there are many other companies which are also having ESOPs, this treasury stocks. So practically how they will be disposed of, they have to ultimately cancel those shares, those treasury stocks, if they are enforcing this law.
Okay, next. Merger of
Yeah, so fast track merger, I think they are trying to simplify, and this provision seems to be a better way to write. Earlier it is 90% of the total shares consent was required to get the scheme approved. Now they are saying 75% of present and voting in the meeting should approve the scheme with simple majority, and plus that should be at least 50% of the total value of shares which are giving the approval to the scheme. Then only it can go on. So that is one good thing. I think some simplification is there. Further, they are, I think, continuously they have made 2, 3 or more amendments. One is they are saying holding company and wholly owned subsidiary was there. So now they are saying even other than wholly owned subsidiary may also be considered, except for certain class of companies which are big in size. Third amendment, which is very, very important, that they are saying all kind of a scheme of arrangements should be covered, not only the mergers. So now demergers and other scheme of arrangement of small companies and wholly owned subsidiary would be covered under this head. So these will reduce the burden of NCLT, and I think NCLT would be able to focus on certain big size M&A transactions, so that that will be faster and simplified. Okay. I think that is a good move.
Okay, next point, Manoj, review.
I have covered all the 3, I think.
Okay. The benches is also, you have covered the criminal.
Yeah, last thing they are saying is special benches. So I think that power is already with the central government, whether or not section is being amended. So special benches of the tribunal may be formed for mergers. That is also very important, because they are saying IBC is being given most preference, and due to that merger cases are getting deferred every time. So it is very important to have special benches for mergers, amalgamation, and for IBC. Separate benches may be there.
Okay.
Recently we have given this proposal to NCLT president also, that where we are having more than 2 benches, at least 1 bench may be dedicated for company law matters. Where we are having only 1 or 2 benches, at least minimum a day should be fixed in a week to deal with company law matters, and particularly M&A matters.
Yes.
Okay. Manoj, next is recognition of special purpose acquisition, SPAC. Now you are aware that in India the shell company concept is seen as a negative, and SPAC is coming worldwide in a very big way. So SPAC, for the benefit of people, the SPAC is the companies are the company has no business, but investors and the investment bankers, they are listing that company, and then they are searching the business for that company, and they have a time of up to 18 months, and till the time, if they are not doing, then they have to return money. So they are collecting money on behalf of investors, issuing shares, listing the, and then searching business, and then business they are merging. So Manoj, now SPAC they are providing in the Companies Act. What is the call on this?
Sir, I think there is 2 types. One in Indian SPACs, where Indian company would be listed without any business for the purpose of investment on target companies, or merging with the target company, or merging the target company into it. So that would be obviously in the jurisdiction of SEBI. But reverse, foreign SPACs may be allowed to acquire Indian company and merge into it, or merge Indian company into SPACs outside India. So that is in the framework of this MCA, and obviously it will require amendments in RBI norms, FDI norms. So I think that is very good. a very important amendment. Our Indian specs should also be considered. SEBI has also, I think, is also considering it. So it will help to do the transactions, do listing fast. There are many of the investment bankers who have capacity to raise funds, and then they can certainly be open to consolidate one or more company in certain line, and that would be faster. So that is a good thing. I think all options of this capital market should be available to Indian people also. So that without saying, that should be there.
Okay. Amit, now the next is Trust Cooperative Society Nidhi. So I'm not giving just you brief in a very short, within 2-3 minutes. And
I think background is that three changes. One is trust. If you recall, there was a provision in section 153 of the Companies Act that no notice of trust shall be registered in the register of member. When the Companies Act 2013 came, that provision was omitted, and that provision was omitted intentionally. I believe that was not unintentional, but now government has rolled back. And let me give one more background. Because if you go to the definition of members, member is one who has subscribed to the securities, one who has allowed his name to be entered in the register of member. That means the person who is capable of doing the contract can only be a member of a company. Exceptions are there in case of holding of shares by minor through their guardian. That may be other exception, but as far as the trust is concerned, trust is not to be considered as a legal person and not capable of doing a contract, and that's where the provision comes in a difficulty, in a restriction. I don't know how the industry is going to react, especially the mutual fund, which is based on trust model only. So if I am saying that trust cannot be the shareholder, then how things will move forward, that clarity is required. Because 153, if it is only that no notice of trust will be recognized, I think it is okay. But if government is saying that trust cannot become a member, I think there can be a bit of challenge. That is point number one. Point number two is with regard to the cooperative society. The government is
sorry. With respect to the first point on the trust, there is no restriction on trust being member of the company. There is a restriction on the notice of the trust getting in the register of members. So trust can be a member. Only thing, what you put in the register of member is what they are now regulating, which is going back to 1956.
So you are saying ABC trust?
It is the trustee whose name is entered in the register of member. Even in the past, trustees' name were there. 153 was not stopping the trustee to become the member. They are holding interest of many of the people or some of the people. So it is not.
But that was the restriction in 153.
Yes. Trust cannot be entered. Name of the trust, because trust is not a body corporate, not an entity, not a legal entity, so it cannot hold shares. It is but like a partnership. Partnership's name can also not enter into register of member. It is only the name of the partner or jointly with the 2 or 3 partners can be entered in the register of member. So same way, trustee will be entered in the register of member. Not the trust.
Correct. But only thing is, trust can be a shareholder. That's not the problem.
The trust is not the shareholder. It is the trustee who is the shareholder. They will not recognize whether he is holding for or on behalf of someone else. It will be that all the obligation and rights would be vested in the trustee itself.
Manoj, if you read SBO rules, the rules say where trust is a member, where partnership firm is a member. They are using these terms that I raised this question.
That is not correct. That is not correct because it is not possible.
Because SBO rules provide, that does not mean ki you have the charging provision to.
I'm not saying that, Amit, but somehow or the other, if government is using such terms,
that is the wrong thing to say.
All I'm saying ki government needs to give a clarity which trust can hold the share, which trust cannot hold the share, and what is exactly this restriction going to be if they are actually going to roll back the provisions of section 153 back to the provisions of law. I think that clarity should be there, otherwise there's going to be a lot of confusion. Now coming on the part of cooperative society, as far as chapter 21 provisions are concerned, by virtue of that provision, which is similar to Part 9 of the Companies Act, where a partnership firm, unregistered entity, or a cooperative society or a society can be converted into a company. They can be registered as a company. Now they have specifically came out with the proposal that cooperative societies will not be allowed to be converted as a company. The background is only that urban cooperative banks have been allowed to be registered as a small finance bank. Government wants to discourage the peoples from using the route of 366 of the Companies Act for converting their cooperative societies to small finance bank, because they are saying that should be a freshly incorporated entity. So government idea is only to encourage a new incorporation to form a small finance bank when a small urban bank wants to convert to a small finance bank. If that is the limited objective to meet the guidelines of RBI, I think for urban cooperative bank, the restriction can be there. But why we are extending to all cooperatives, I think this is beyond my understanding. At least I am not able to understand why government now wants to discourage the conversion of cooperatives into a company. I don't understand. So if at all there is a requirement, you stop the UCB to small finance bank. Now that's the suggestion that we can give to the government. Per se, there should not be a blanket ban.
Okay.
The understanding is that cooperatives are generally not for business, whereas this is not true. Amul is for business. There are many cooperatives which are doing the business only. So this understanding is also.
I mean, next Nidhi point. Just come to the Nidhi point.
Sir, Nidhi point is also, I think, if I am not wrong, this amendment came long back in the year 2019. 15 August 2019, the amendment was there. If you recall, sir, this provision of 406 under the Companies Act 2013 is a replica of 620A of the Companies Act 1956, right? Under the 56 law, there were only 1,000 nidhis which were registered, because there was a requirement that government will publish the notification in the official gazette. That means the government approval was required to be recognized as a nidhi, right? Now under the 2013 law, everything was liberalized. You were simplified that you simply have to have a 20 member and 10 lakh rupees of capital, and you can register yourself as a nidhi. So from 2014 to 2019, this regime continued, and 10,000 nidhi companies were incorporated, which were not subjected to any government check and approval. Now in 2019, though the amendment came, but there was no notification. Now CLC has again recognized, because there are a lot of complaints which are now being coming to the ministry knowledge. So they are now over regulating the nidhi companies. They are saying now you cannot register a nidhi, or you cannot function as a nidhi unless and until government gives a notification. So the process of incorporation is that you will incorporate, you are given 3-month window, and after 3 months, within 3-month window, you have to increase your number of members to 200 and capital to minimum prescribed and meet other parameters what the government prescribed. Then government by official gazette notification will declare that company as a nidhi. Fit and proper person criteria has also been introduced. So I think intention of the government is good. Government wanted to weed out the wrongful people from the entering into this particular business by doing this. But I think what they will do for the companies which had been already incorporated from 2014 till date, they have already given, I think, 2 to 3 year time. They are saying they will be allowed to register, or they have to close down their business. In nutshell, it's a good move to protect the interest of investors.
Amit, last point related to producer LLP, that now they are saying a producer company can also.
I think that it's a win-win situation. I'll say, because why limited liability partnership? We need not discuss more as to what are the advantages of a limited liability partnership, because it's a hybrid of partnership and the company. So you get the advantage of both, right? So now if a producer company is also allowed to be formed in form of a limited liability partnership, it will immensely benefit their partners.
Okay.
One advantage I can tell, one advantage is if I am a producer company, if I want to declare a dividend, the income is taxable in the hand of the producer company unless it is exempted by virtue of provisions of law. Then it will be taxed in the hand of the receiver also. Whereas in the case of LLP, it is only single point tax. So producer LLP will pay the tax, and the distribution of profit to the partners will be tax free. So I can understand the advantage that is going to flow out of this LLP producer company. And in addition to that, there will be a lot of other advantages in terms of audit and small, basically, not very big one.
Okay. Amit, now last point is that there are some drafting clarification. So I'm not going to one by one. Any suggestion relating to this, that these are the changes which will impact?
I'll just highlight one change which while I was reading this report drew my attention. That is with regard to the related party transaction. Now, related party transaction penalty punishment has been decriminalized. Now, government is saying that even if you are levied a penalty, you will be subjected to a disqualification and vacation under section 167. The same trigger will continue as was there earlier. Now, difficulty is that in case of adjudication, the authority of adjudication is administrative. Earlier, the criminal trial was taking place before the competent court, which was a special court. There you were having ample of opportunities to produce the evidences and other things to protect yourself, to protect your interest, and the fine was not levied. In the administrative jurisdiction, you don't have that type of opportunity, and the fine will be levied and you will be vacating the office. That is the consequence. So there is no point of linking both these things together. 188 should be separate, and linking 188 to 167, I think is not correct in my mind.
Yeah.
Okay.
So there are just 2-3 points in the drafting and clarification. I feel these are not clarificatory changes, these are big changes. Because one of the change, which is the third point over here, it says about the holding company and the wholly owned subsidiary. Now they are saying that wholly owned subsidiary can have only one member, and holding company, whether private company or public company, and wholly owned subsidiary can be a one member company, and that will not be an OPC. So we are creating another class of company, and that is whether it's private company or public company, which is a holding company. So it is a big change.
But Gaurav, I think that's an appreciable move. I think
no, that is appreciating, but I'm saying that there are consequent, there are many changes to it.
Company, all the compliances of the holding company would be applicable. Only thing is there is no need to have nominees, 7 nominees, 6 nominees.
Yeah, exactly. 187 compliances.
We have been demanding this provision for quite long time. I think it's a welcome move.
Okay. Now, friends, there are few questions which I'm taking. One is risk management committee should be left with the wisdom of business house, the need for such committee policy. I think the question which has asked Karthik, that I think the risk is now very, very important, and somebody should know. In a day, business will evaporate. So that's why they have realized. Otherwise, the advisory was there, the risk management committee should be there, but now they want to make it compulsory. And this is no, I don't think this is any, because sometime when you have a specific committee, then they will put more focus on its risk aspect. Second question, he's asking, EAGM should do away with the requirement of quorum. In a smaller listed company, 30 members are not showing up. Okay, in BC, another thing. I think this 30 members are not showing, that's a separate part. But any call on Amit, is the 30
Sir,
members?
I think point is valid, especially during the peak period where the several AGMs, like 30th of September of any year, there may be n number of AGM scheduled. So getting a quorum of 30 is a challenge for especially small companies. So because for physical meeting, there was an attraction that at least the lunches will be there, or there will be something else. But in VC meeting, you don't get such type of attraction. So government, the companies have to be innovative to attract the participants to the VC meetings, I think. But point is valid. There are concerns that we are not able to get the quorum even minimum.
On resignation of auditor, the requirement of giving reason is also required under SEBI LODR. We still see auditors companies are not providing detailed disclosure. How will the provision be enforced? I think that is a one suggestion. It is a process. That's why they are saying a structured point they want to give. Okay. What will be the status of shareholder after transfer of IEPF?
They will remain shareholder.
Yeah. Okay. Somebody is asking why 7 years only. It may be more or less.
I think 7 years is a concept in the criminal jurisprudence that if a person is not found
So
for
it will
7
be
years, then he is
dead.
found.
Okay. Okay, Manoj, it should be made automatic process in case of merger or takeover, etc. by foreign company.
It is automatic. Rule 25A was inserted. Now RBI has also given the clarification that cross-border merger, the amalgamation can happen in case of companies are falling under automatic route of FDI.
Okay, Gaurav, how feasible is maintenance of statutory register through electronic platform, particularly in the minutes, including board meetings?
Yeah.
Board minutes.
Sir,
We cover.
actually, minutes, there is no reference of minutes, so only statutory registers. And they have said that everything will be masked. And in case of any investigation, then it will be unmasked. And then the data can be accessed. Even the government will not have.
Okay. Madan sir, as a secretary standard, you are expert in this. You have any comments on this?
Yeah, I agree with Gaurav.
Okay. Okay. So, friends, one question has come. What is the difference between the RSU and SAR? I think we will have a separate program on this, and ESOP program we will explain to everybody this because time is short. So, friends, thank you very much. We have covered the entire CLC in a very crystal manner, and each and every point we have discussed. So, if you have not read this report and you have attended this program, or if you have not attended this program, you can communicate to your friends. They can go to the YouTube channel and they can see this. So entire point will be clear. So thank you very much, Gaurav, Amit, Madan sir, Manoj, Mohini, Ankit in absentia, and all other participants, those who have still they are here when 6:20 is already. It's a time of 6:20, I think. So thank you very much to all participants. So we will continue to share our knowledge and our journey because so many new changes are coming in ESOP, buyback, delisting, IPO, LODR, deals, merger, and we will continue to hold these type of program. Anybody wants to communicate to us that what types of program they are interested, please write to us. We will do it. If you have any query, any doubt, any clarification you require related to CLC report, please write to us. We are eager to reply you, and we are all our speaker are knowledge hungry, so they want to share. They have earned the knowledge. Now they want to return the knowledge to all our the corporate world. So thank you very much to all my learned participants as well as my learned speakers, those who have joined today. Friends, we will take excuse from you because next Friday we have our annual business meet at Manali, and we have I was trying to have this program continuously, but the place where we are going, the connection is not good. So I will just work out whether Madan sir or Amit Gupta can lead and continue this program. Otherwise, if it is not possible, so we will meet after the next Friday to next Friday, and we will have the discussion more on new subject, new topic with new speakers and with new questions. Thank you very much. See you.
Thank you, and my compliments to you, Pawanji, for again being a pioneer as usual and holding this event within 1 week of the release of the report. Congratulations to you and the entire team.
Thank you very much. Thank you. Okay.
The best part is that many of the suggestions what we at this forum had discussed and given to ministry had been considered by CLC, and they have been considered as well.
Yes, because all other program which we have done, we have made always after the program, our team is working, making suggestions, compiling and send it to the NCA, SEBI, and SEBI has taken through our program so many suggestions they've included. So that is a return which we are getting from the regulator. Thank you very much.
Great, sir. Great.
Thank
Thank you, sir. Thank you.